Right now, federal prosecutors are holding a press conference in Brooklyn. They're going to officially announce a decision not to file civil rights charges in the case of Eric Garner's death. Let's listen in.
That after an exhaustive investigation, the Department of Justice has reached the conclusion that insufficient evidence exists to prove beyond a reasonable doubt that the police officers who arrested Eric Garner in Staten Island on July 17th of 2014 acted in violation of the Federal Criminal Civil Rights Act. Consequently, the investigation into this incident has been closed. We met with Mr. Garner's family earlier this morning and shared our findings and decision with them. I offered my sincere condolences, as well as the condolences of Attorney General Barr and the entire department to the family for this tragic loss. This morning, I want to discuss the reasons for our decision and how we reached it. While the department does not normally publicly discuss a decision not to bring charges, we felt that this matter is an exception because it means so much to our community and beyond. Before I continue, let me say as clearly and unequivocally as I can that Mr. Garner's death was a tragedy. For anyone to die under circumstances like these is a tremendous loss. For the family to suffer, as this family has for too long, has only compounded the loss. But these unassailable facts are separate and distinct from whether a federal crime has been committed. And the evidence here does not support charging Police Officer Daniel Pantaleo or any other officer with a federal criminal civil rights violation. Admittedly, many may disagree with this decision, and that is their right. However, we hope that by announcing and explaining our decision today, we can bring some measure of closure to one of this city's more upsetting incidents involving the police and a member of our community. To fully understand how we made this decision, I want to briefly discuss the applicable law. In order for a federal criminal civil rights charge to be brought, the government must prove, beyond a reasonable doubt, 4 elements. First, that the officer acted under color of law. Second, that the officer used objectively unreasonable force under the circumstances. Third, that the officer violated the law willfully. And fourth, that the wrongful conduct caused bodily injury to the victim. In simpler terms, this means that the government must prove beyond a reasonable doubt that an officer willfully used more force than he reasonably could have believed was necessary under the circumstances. During the department's investigation, we focused primarily on 2 of these elements. First, whether the force used was objectively unreasonable under the circumstances, and second, whether the officer acted willfully in violation of the law. The reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with 20/20 vision of hindsight. And the law recognizes that police are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. However, even if the government can prove beyond a reasonable doubt that the force used was objectively unreasonable, the government must also prove beyond a reasonable doubt that the officer acted willfully. This is the highest standard of intent imposed by law, and it is different and higher than the intent standard under the relevant state statutes. While willfulness may be inferred from blatantly wrongful conduct, such as a gratuitous kick to the head, an officer's mistake, fear, misperception, or even poor judgment does not constitute willful conduct under federal criminal civil rights law. What all of this means is that even if we could prove that Officer Pantaleo's hold of Mr. Garner constituted unreasonable force, we would still have to prove, beyond a reasonable doubt, that Officer Pantaleo acted willfully in violation of law. Eric Garner's arrest was largely captured on video, and the video has been replayed in the media on countless occasions. Like many of you, I have watched that video many times, and each time I've watched it, I am left with the same reaction, that the death of Eric Garner was a tragedy. And I know that every one of my colleagues who reviewed the video share the same sentiment. The job of a federal prosecutor, however, is not to let our emotions dictate our decisions. Our job is to review the evidence gathered during the investigation, like the video, to assess whether we can prove that a federal crime was committed. When viewed in its entirety, the video documents a tense and escalating encounter between Mr. Garner and the officers, and shows that the officers had to make split-second decisions under stressful circumstances. The video shows that the officers' initial actions were in accordance with established police tactics and procedures, but that the situation deteriorated as it progressed. At the end of the day, however, the video and the other evidence gathered in the investigation does not establish beyond a reasonable doubt that Officer Pantaleo acted willfully in violation of federal law. Now let me address the video and some of the other evidence. On July 17, 2014, Officers Justin D'Amico and Daniel Pantaleo attempted to place Eric Garner under arrest. The officers were acting that day under direct orders to address complaints about the sale of untaxed cigarettes in the vicinity of Tompkinsville Park in Staten Island. Mr. Garner resisted arrest, both verbally and physically, and consequently, the officers were permitted to use force to effect the arrest. That force, of course, had to be reasonable. After Mr. Garner resisted arrest, Officer Pantaleo appeared to attempt 2 approved NYPD tactics, both of which involved the use of force. First, he appeared to attempt an armbar, which involves pulling the hand of a person down while the officer goes behind the person to gain control of him, to put handcuffs on him. As the video makes clear, Mr. Garner twisted his body and freed his arms, evading Pantaleo's grasp, and avoided being placed in handcuffs. Officer Pantaleo next appeared to attempt a second approved tactic, this one called the rear takedown or seatbelt. In this tactic, an officer places one arm under a person's armpit and the other hand across the shoulder and chest of the person in order to unbalance the person and bring him to the ground. Here, Officer Pantaleo placed his right arm under Mr. Garner's right armpit and his left arm on Mr. Garner's shoulder and upper chest, with his left palm facing out and away from Mr. Garner's neck. At this point, there is nothing in the video to suggest that Officer Pantaleo intended or attempted to place Mr. Garner in a chokehold. I would also note that there was a significant difference in size and weight between Mr. Garner, who stood 6'2" and weighed close to 400 pounds, and Officer Pantaleo, who was considerably smaller. And it is clear that this disparity in size and weight contributed to Officer Pantaleo being unable to bring Mr. Garner under arrest quickly and without further incident. Officer Pantaleo then attempted to complete the rear takedown to put Mr. Garner off balance. This is where the situation rapidly deteriorated. As Mr. Garner and Officer Pantaleo struggled, Officer Pantaleo held on to Mr. Garner, and both men fell backward. In the process, Officer Pantaleo's body slammed against a store window, causing the window to buckle. It appears that in response to that collision and to maintain a hold on Mr. Garner, Officer Pantaleo wrapped his left arm around Mr. Garner's neck, resulting in what was, in effect, a chokehold. Officer Pantaleo maintained that hold on Mr. Garner for a total of approximately 7 seconds. During the first few seconds of that hold, the two men were falling to the sidewalk. As has been widely reported, Mr. Garner stated, "I can't breathe." But I would point out that he made this statement only after he fell to the sidewalk and after Officer Pantaleo released his grip from Mr. Garner's neck. Significantly, Officer Pantaleo was not engaged in a chokehold on Mr. Garner when he said he could not breathe, and neither Officer Pantaleo nor any other officer applied a chokehold to Mr. Garner after he first said he could not breathe. I want to repeat that last statement because it's very important to the understanding and analysis of this case. Officer Pantaleo was not engaged in a chokehold on Mr. Garner when he said he could not breathe. And neither Officer Pantaleo nor any other officer applied a chokehold to Mr. Garner after he first said he could not breathe. It is also important to understand that there is a disagreement among medical experts regarding the cause of Mr. Garner's death. While the medical examiner who conducted Mr. Garner's autopsy ruled it a homicide, meaning that the death resulted, rightly or wrongly, from the actions of another, another medical examiner who reviewed the autopsy report could not conclusively determine whether the chokehold itself caused Mr. Garner's death. At least two different medical experts have explained that the sudden cardiac arrest suffered by Mr. Garner could have resulted from a number of causes in addition to the chokehold, including being restrained in a prone position, damage to his neck area that was not attributable to the chokehold, and Mr. Garner's serious underlying medical conditions. This is significant because it casts doubt upon whether the chokehold itself directly caused Mr. Garner's death. When we evaluated Officer Pantaleo's actions in light of his training and experience, Mr. Garner's size, weight, and actions to resist arrest, and the duration and escalating nature of the interaction, we determined that there was insufficient evidence to prove beyond a reasonable doubt that Pantaleo acted in willful violation of federal law. As a result, we conclude that there is insufficient evidence to bring a federal criminal charge against Officer Pantaleo for his role in the untimely death of Mr. Garner. Before I conclude, I also would like to address the timing of today's announcement. As I mentioned earlier, this investigation was extremely thorough and time-consuming. And the recent administrative hearing conducted by the NYPD provided, at least potentially, one last opportunity to develop evidence that might have put us in a position to bring charges. But regardless, today's announcement is long overdue. We, the department, owed it to Mr. Garner's family and the community to complete the investigation and announce our decision earlier. I should emphasize that this was a very difficult decision, and it was one that was contemplated and considered at the very highest levels of the Department of Justice for several years. For the family, for the community, and for the cause of justice, please know that experienced, highly trained federal agents and career prosecutors worked hard to investigate and examine the facts to determine if a federal criminal case could be brought here. The department remains committed to aggressively investigating allegations of excessive force by police officers and others, and will continue to dedicate all necessary resources to doing so. We are committed to aggressively prosecuting excessive force cases whenever there is sufficient evidence to bring them. Mr. Garner's death was a terrible tragedy. But having thoroughly investigated the surrounding circumstances, the department has concluded that the available evidence would not support federal civil rights charges against any officer. We know and understand that some will be disappointed by this decision, but it is the conclusion that is compelled by the evidence and the law. Thank you. I know that there will be questions. There will probably be more questions than we can handle in this forum. We will take a few of them now, and if there are subsequent questions, please direct them to our PIO, and we'll do the best we can to answer them. Sir.
Ron Allen from NBC News. Because this case is so complicated, and you point out that there are inconsistencies like the cause of death and so forth, and because the public has seen this video tape as you have, it sounds to me like some of your critics would say that you are playing the role of judge as well as potential prosecutor. Why not let a jury decide all these facts? And don't you think that your decision would perhaps have more widespread support and less criticism, if you will? If a jury decided, why not let a jury decide?
We would certainly understand that view, but as federal prosecutors, there are two things that we have to be satisfied with before we present a case to the grand jury. That is set forth in the Justice Manual, which guides the procedures and policies of the department and has long done so. First, as federal prosecutors, we must actually be convinced beyond a reasonable, that we can present evidence beyond a reasonable doubt that the defendant has committed the crimes charged. Second, we must be convinced that there is sufficient admissible evidence at trial, both to gain a conviction and to sustain it on appeal. Because in this case, after the full examination of the evidence, we've determined that we, as the prosecutors, are not convinced that this particular defendant or potential defendant committed the offense. We would not go ahead and present it to the grand jury under long-established department policies.
Despite what we see on the videotape, you're saying this wasn't even close.
I'm saying it was a difficult decision, and that's in part why it took so long. Certainly there was a desire by many people who worked on this case over many years to do everything we could to determine whether charges could be brought. I would say that obviously the fact that it was on video made this different from some other cases where we don't have that sort of compelling evidence up front. But I'm not going to gauge whether it was close or not close. I'm just going to say that we put a lot of time and effort into this. There was a lot of thoughtful discussion within the department, and this is the conclusion that is driven by the evidence in the law. Ma'am?
Can you describe the meeting with Garner's family this morning? Did you meet with them personally? And they expressed the concern, saying that they weren't given an explanation about your decision, lying, just condolences. So can you share a little bit?
I did, yes. We did meet, my leadership team and I met with the Garner family and some of their advisors this morning. It was not a comfortable meeting because it's very difficult, obviously. And they were upset, and they had questions that we tried to answer. I will say, as one of their advisors pointed out in the meeting, that the family has consistently called for peaceful protest in the spirit of members of our society who have the best interests of our city at heart, and I echo that. We did our best to try to explain why we reached the decision that we reached. but obviously it was a difficult discussion with the Gardner family. I did express my condolences, the condolences of Attorney General Barr and the department, and I apologize to them for how long this took, because the delay certainly is regrettable and inappropriate.
Sir, if you could, can you expand more on that about the delay in terms of why it did take so long? It's one of the criticisms here. We went through several different U.S. attorneys, different attorney generals, different civil rights attorneys over at DOJ. It sounds like there was a problem here. And just if you can explain, is it a problem that it took so long? Is that in any way affecting the investigation?
This should never have taken as long as it did. I don't think that the delay in any way compromised the investigation. This is not a situation where evidence was lost or memories faded. People were interviewed immediately after the incident, and more than 46 witnesses were interviewed: law enforcement, civilian, expert witnesses in the use of force, medical examiners, and others. So I don't think that we lost evidence by the delay, but the delay was entirely inappropriate and unacceptable. And as you said, we've had a number of changes, U.S. attorneys. I think there have been probably 5 AGs who've considered this case. Certainly that was part of it, but I do think it was a delay due in part to the fact that people wanted to be absolutely certain that we had looked at every factor and every aspect of this case before a decision was made to decline it.
One more question. Can you speak one more question?
Between this office and the Civil Rights Division of the Justice Department?
I'm certainly not going to comment on the internal deliberations of the department. I will say that we have over 100,000 employees, and everyone has their role. There was a tremendous amount of discussion within the department over years, in part because of changes in administrations, tremendous amount of briefing, a tremendous amount of discussion. I will say that at the end of the day, Attorney General Barr thoroughly considered this case and made the decision himself, and that is the decision of the department. Okay. I understand. I'll address this, and then I'll ask that you direct any further questions to the PIO, and we'll answer them the best we can. I know there's an issue about statute of limitations. So the way this comes into play in this case is there are questions about exactly how these different factors, including the chokehold and other things, contributed to Mr. Garner's death. Because of that, and because of the questions about what exactly caused the death and what combination of factors caused the death, we viewed this as being a case where the government, if it could prove a case at all, could prove beyond a reasonable doubt, perhaps, that Mr. Garner suffered serious bodily injury as a result of the officer's action. That charge has a 5-year statute of limitations. And that's why, in abundance of caution, we made sure that it was thoroughly reviewed and a decision was made before that 5-year statute of limitations was triggered. Again, thank you all. You can direct further questions to the PIO, and we'll address them the best that we can. Thank you for being here today.
So U.S. attorneys just officially announced that they are not filing civil rights charges in the case of Eric Garner's death. He said that there was not enough evidence to show that the officer who arrested Eric Garner violated the Federal Criminal Civil Rights Act. He said they could not prove that Officer Pantaleo, who was accused of placing Garner in a banned chokehold during his arrest, intended or attempted to place Garner in a chokehold. Prosecutors said that they are hoping to announce the reasons behind the decision will help bring closure to the case. Tomorrow marks 5 years since Garner's death. Earlier today, Eric Garner's family spoke after meeting with Department of Justice attorneys and said that they will not stop fighting. They also called for NYPD Officer Daniel Pantaleo to be fired immediately.